I think, Honorable Nyeko, what my statement says is exactly what the bill is saying in 31D. What you're raising is in 31D, the clause 31D about what can be murder. This one here does not give the court-martial. 31D does not give the court-martial the jurisdiction to try murder. It doesn't give them the jurisdiction to try murder per se. It can only try murder if it is aided and abetted by a soldier. So if I'm a civilian and I go and commit murder on my own without anything, without the assistance of a soldier, the court-martial has no jurisdiction over me. Yeah? But if I committed it, if we went and broke into, you see the issue, and colleagues have spent some time with these men in uniform, and they've taught me a few things. The issue here is there are skills that they acquire in their training which are not available to you, a civilian. When a soldier is jumping over a wall, he has a skill which has been given to him in the military to use to defend the country. Now, if you, a civilian, were to get over a wall, you may need a ladder, ropes, and etc. A soldier may not need that help. So when this soldier comes and jumps over the wall, then opens for a civilian, then you go in and commit murder, you have used a skill available to a soldier in the commission of your offense. So what the military is telling you, you want to commit your offenses, go and do it alone. If you do it alone, the court-martial will have nothing to do with you. But if you go and involve a soldier in it, you are bringing yourself into the ambit. That's what that provision was saying. And Honorable Mpuga, you are talking about what provisions give, and I hope I understood your question to mean what in this law makes the court-martial a court. If I understood it correctly, then I refer you to clause 35.9, clause 36.13, and clause 38.9. The creation of a court is by vesting it with jurisdiction. The moment the parliament vests a tribunal or a court with jurisdiction, it has become a court. So that's what deals with that. On the issue of the vice, I think that they've had Honorable Kiryowa.
Can you clarify? And you see, that's where the Honorable went on to ask, why then appellant jurisdiction is from the court-martial to the Court of Appeal? Is it then a high court?
No. I think we need to just go back and review what we are thinking about. But I think the law is talking about similar. That if I looked at it from a distance, what would I think that person is? If, for example, a person is running out of this building, putting on this uniform, wouldn't you ordinarily think that is for the soldier? That is where it is supposed to avoid confusion. So if you have a red beret like you have for NUP, if you're in a crowd, a person looking at you at a distance, would they think it is NUP or military police? That's the issue. So when the law is looking at those issues, it is looking at about the similarity and likely to confuse. Obviously, there will be extensions where we are discussing black shoes. So that is the comment on that. But I think that is a policy issue we need to look at and understand how can we best, what is it that we would look at as contradicting what the army uniform would be. And Honorable, the question of framing is criminal in itself. So, but that is another matter. If they are framing someone and putting a material in their house, that's criminal in itself. So we try to write a law, but we write the law for human beings. Human beings, by their nature, we try as much as possible, but they are going to fail in certain instances. That's why you have the laws. So it is that framing is definitely criminal, and we need to address it. And I think it's for us to think about what kind of safeguards can be put in place on both sides. As Parliament, what safeguards can be put in place to ensure we address that issue. On the issue of Ogwang that Honorable Abdallah raised, yes, in that case, the court faulted the use of appeal as made by an instrument signed by the minister. The court said in the Ogwang decision that a minister cannot vest jurisdiction of appeal by an instrument. Jurisdiction of a court is vested by Parliament through principal legislation. So by bringing this here, we are asking Parliament to grant the principal jurisdiction not by statutory instrument, by principal legislation. So yes, it would be curing that. On the security of tenure, we discussed it and we can continue discussing it. The Army has a challenge on the stages of retirement, which are not necessarily the same as ours in the civilian life. In civilian life, we say a judge will retire at 65, and that person leaves the public service. But in the Army, people live at different stages of life. So some people live at 45, others at 50, others at 55, others at 60. So if you say that the person shall retire from the service of the court martial at, say, the age of 60, that person may be way past the stage of their retirement, but that's a consideration we could have. On your recommendation to have the DPP participate in prosecution, that would contravene Article 1, Honorable Abdallah. You had proposed that we have the DPP sanction the charges under the court martial. And I was saying that would require a constitutional amendment because the Constitution under Article 123B specifically prohibits the participation of the DPP in matters before the court martial. Honorable Abdul Katuntu raised a number of issues. I'm going to leave the issue of the monopoly of the Army and ETC to the experts in these weapons. But what I know is that for the AK-47 to be used by police, it needs to get permission from the Army. That I know from my interaction with them. For prisons, even private farms to use AK-47s must get the permission of the Army. So, but they are here, they will be able to explain to you how that works. Then on competing jurisdiction, I see what you're saying. I think the only difference here is that if I have a firearm lawfully and I shoot someone using that firearm, and I shoot someone and injure someone, there is no question of me going to the court martial. It doesn't exist. Because I have the firearm lawfully, but I've committed an illegality with that firearm. Yeah. Yes, now that unlawful possession of the firearm would be charged by the court martial. But if you look at the law, if you have an unlawful firearm as an individual, and you go and commit murder without the assistance of a serving officer, you have the firearm illegally, you go and commit murder using it, that you will be charged in the court martial for that unlawful possession of that firearm. So if you have it lawfully and you use it for an unlawful act, you will be tried by the civilian courts. Why? Because at least you made the effort to go and report yourself that I have a gun. So that is the thing. Now, on parallel jurisdiction, I think the issue would be you can be tried in both places. And that happens in many instances. You can be tried in both places, but I think the issue is that both of them have jurisdiction. Both the High Court has jurisdiction over the murder you have committed, and the court martial has. The issue that we have is that if you are in concert with a soldier, then the court martial also has jurisdiction. Now the problem we are having is that if you take the soldier the other side to be tried in the court martial, and you take the civilian this side, the trial of those. Yeah.
Because you can't try people for the same offense.
In two different places, yes. So the issue of possession of the firearm and the detail of it is what I'll leave to the experts. Because some experts sent me here, like for example, there is a bayonet which is attached to the gun. That bayonet which is attached to the gun, they're not expecting you to find it in a shop roaming around with it. That bayonet is the preserve of the army. So, but they'll give you more detail. To the Court of Appeal, we're just borrowing an experience from the industrial court. We're just borrowing an experience from the industrial court, where the industrial court decisions are appealable to the Court of Appeal. But that, again, like I said, the jurisdiction of any court is determined by Parliament. Clause 57, I wanted us to, Honorable Katun, to erase clause 57, and maybe it may be our drafting which we may need to clarify. Clause 57, any party to the proceedings of a court-martial who is dissatisfied with the decision of the court-martial shall have the right to appeal to an appellate court on any of the following matters: legality or propriety, legality or the whole or part of the sentence, severity or leniency. Subsection 1 shall not affect the operation of any sentence imposed by the court-martial other than the sentence. So here, what we're trying to say here is that if a person is convicted of and sentenced to death, you cannot go to the Court of Appeal and say, what is the legality here? What is the severity here? The person sentenced to death should be at liberty to bring whatever issues that they may want to bring. Secondly, you cannot execute that death sentence before this person has exercised all their appeals. And if the person is appealing to the Court of Appeal, you must wait for the Court of Appeal. But if a person has been sentenced to 20 years in prison, he starts serving the sentence. So I think it's an issue of drafting.
No, that's bad. This is bad drafting.
Yeah,
I hear you loud,
yeah.
but this is not what
it
has to be redrafted.
When you're speaking to it, I could understand where you're coming from. I think we'll need to clarify on the drafting there. And then on you at page 15 and on the composition of the court-martial, I think what the military was looking for was co-opted. This person is co-opted. What this provision is saying is that the president has the power to co-opt someone into the high command. So that is what EU is saying. And 7E, people should be a member of the high command. That is a policy issue, like you said, and they will help us with. What is the issue? I agree with you. The issue of civilian in court-martial. I'm going to end with the most controversial, because it was a question that channeled through almost every question. And I want to go there last so that I can leave immediately after that. But but it is a matter that I need us to be clear about. I think, Honorable Nyeko, what my statement says is exactly what the bill is saying in 31D. What you're raising is in 31D, the clause 31D about what can be murder. This one here does not give the court-martial. 31D does not give the court-martial the jurisdiction to try murder. It doesn't give them the jurisdiction to try murder per se. It can only try murder if it is aided and abetted by a soldier. So if I'm a civilian and I go and commit murder on my own without anything, without the assistance of a soldier, the court-martial has no jurisdiction over me. Yeah? But if I committed it, if we went and broke into, you see the issue, and colleagues have spent some time with these men in uniform, and they've taught me a few things. The issue here is there are skills that they acquire in their training which are not available to you, a civilian. When a soldier is jumping over a wall, he has a skill which has been given to him in the military. to use to defend the country. Now, if you, a civilian, were to get over a wall, you may need a ladder, ropes, and etc. A soldier may not need that help. So when this soldier comes and jumps over the wall, then opens for a civilian, then you go in and commit murder, you have used a skill available to a soldier in the commission of your offense. So what the military is telling you, you want to commit your offenses, go and do it alone. If you do it alone, the court martial will have nothing to do with you. But if you go and involve a soldier in it, you are bringing yourself into the ambit. That's what that provision was saying. And Honorable Mpuga, you are talking about what provisions give, and I hope I understood your question to mean what in this law makes the court martial a court. If I understood it correctly, then I refer you to clause 35.9, clause 36.13, and clause 38.9. The creation of a court is by vesting it with jurisdiction. The moment the parliament vests a tribunal or a court with jurisdiction, it has become a court. So that's what deals with that. On the issue of the vice, I think that they've had Honorable Kiryowa.
Can you clarify? And you see, that's where the Honorable went on to ask, why then appellant jurisdiction is from the court martial to the court of appeal? Is it then a high court?
No, a stage where we believe that this jurisdiction is dropped in a particular way. For example, for appeals to an election petition, this parliament said you will not appeal to the Supreme Court. So what this parliament vests you with is what you use. The industrial court was vested with mandate and sent to the court of appeal. It was by this parliament. So the constitution did not tell this parliament where to vest the jurisdiction. So you can vest the jurisdiction. The
No,
question
but you
is,
see at that point, as you realize, the court, the industrial court was now being presided over by high court judge.
and now we are, you see, the industrial.
That's why we said no, we cannot have a high court judge in the industrial court taking a decision that is being looked at by a judge of the similar rank. Therefore, it should go up.
I think that is a conversation you'll have, but you must remember that the industrial court also has two civilians who are not necessarily legally trained. So, but that's a conversation that what I need to state as a matter of law, the decision on the jurisdiction to be granted to any tribunal or court vests with the parliament. So we are asking you, parliament, to grant the Court of Appeal jurisdiction over the decisions of the General Court Martial.
This is just for your take home. I beg to disagree with the use of the example of the industrial court. We are talking about a criminal offense here. It's homework for you, but I want you to address that.
I think it's homework for the parliament, because me, I am not the one who vests jurisdiction.
Yeah.
Me, I've asked you, and I've told you what we think, and the reasons why we think so. Now,
Mr. Chair,
okay.
We are not trying to pull ropes here. Like we are listening to him, and we do the correct thing for the...
Are you persuading the Attorney General such that the appeals go to High Court?
Yes.
Is that what you are saying?
Yes, that's what
Okay.
we've been saying. But he can think about
What
it if he thinks it makes sense.
But it's also important.
Or
to
you are
note-
leaving it to us just
we shall
to
think
decide.
about it and also share with you whatever other material we can find on
Yeah,
this.
like-
But it's also
Okay.
important to take note of what he has said. Jurisdiction is really our mandate. Yeah. Could we-
responsibly.
Yeah, sure.
Okay. Civil tried. I'm going to deal with that. The issue of schedules. I think the issue of the schedules, we are going to have a conversation with the minister on that, and we understand what these schedules and explain them a little more. The experts are here on those schedules. Dry ratios, I agree. I agree that because if for example you take the fuel of soldiers, who are being sent to war, and you in concert, you a civilian in concert with an army officer, you decide to steal the fuel of the army. Why should you come to the, why do you, when you're stealing the things of the army, why is it okay to go to the army, but when they are trying you say, now me I'm a civilian? Why don't you remain a civilian and stay away from the things of the army? So Honorable Chairman Sweat, I agree with you. If they find you with army rations, what are you doing with army ration? But I think the issue again goes back to what safeguards have been put to the concerns of the members. Independence of the court, and I think this was Honorable Odu raised the issue. I think independence of the court is, like you said, is a wholesome issue. And independence of the court starts from independence, impartiality starts from composition, how they conduct themselves, and tenure. All those lead to independence. And I think the Chief Justice addressed himself severally on this issue at page 193 of his judgment, and taking oaths. He talked about taking oaths that you are talking about. Taking oaths is one of the issues of independence. Impartiality, both subjective and objective, is legal qualifications is part of the independence. How can you be independent rendering judgment when you have no knowledge of the law? Composition was part of this, tenure, manner of appointment. So all those are part of the independence. So if what we are trying to do here, honorable colleagues, is we are trying to clothe the General Court Martial with all these different tenets to try and give it an independence. Now we'll ask for your guidance if you think there is anything that we have indeed left out, and we shall.
Because you seem not to have understood me. I was addressing the two-color relationship between the three arms of government.
Yes.
And I think that is the gist of what the court, Supreme Court addressed, that the executive has the control. These charges are brought in the name of the state, controlled, and you are the one in charge of deciding on this and fabricating or manufacturing.
Just like.
So, yes. So that's where I want you to know.
I get what you're saying, but I think.
And maybe now I can add this so that the army can help us understand. You talk about the oath. There are also oaths that are taken in the army, the oath to obey maybe your army commander or something like that. So if we give the example now of what is happening, and a brigadier general is now presiding over, and an order comes from a superior officer.
I think the most important.
That's what we are talking about.
I think the most important thing is that this oath that we are talking about is in the Constitution. The other one is in the Act.
And I can say there is evidence that in one of the proceedings of the court-martial in this country, before a decision was taken, it was taken to be discussed in the high command, whether it should proceed. History has it. So that's the kind of interference we are talking about. That if a court that should make a decision then says now we go to the high command whether now we should do.
And honorable.
So that's what I want.
That's what we are trying to cure here. So your guidance on what you think we should add, because we have put for appointment, we have put for tenure, we have. So you could also add and say, I think you may want to add this aspect to make it better, but we will be happy to.
No, let the record be clear that I have said it is unconstitutional under all circumstances.
No.
To try. No, I just want your record, so don't tell me to add.
I am going to show you
to escort
when I end,
that.
because I said I want to end with that. I want to show you that you are wrong, that not even the Constitutional Court said that, not even the Supreme Court said that. But I'm going to get to that. I said it was the last one. So now on the definition of service offense. The purpose of amendment of this service offense, I think we need to be clear. The Act as it is now makes the court-martial try civil service offenses and any other offense made under any law, which the court in that judgment called the civil offenses. What we are trying to do here is by saying no, service offense means only that offense which is under the UPDF Act. So all the other offenses which are in other acts is not a service offense. That's what we are saying. Then Honorable Brandon, I think I was talking about Jamil Mukulu. I think Jamil Mukulu's case is slightly different because Jamil Mukulu is charged under the International Crimes Division Act, which is a manifestation of the Rome Statute, which has a different jurisdiction. This is dealing with genocide and different things. So when you say that Jamil Mukulu was being tried in that, it was being tried there because of Section 9 of that particular act. Now, that act that we brought in, Section 7, 8, and 9 deal with genocide, crimes against humanity, and war crimes. And that is specifically derived from the Rome Statute. So that is the explanation why. So when we entered the Rome Statute, we agreed that if a person commits such kinds of offenses, they will be tried in a court which has structures and jurisdictions which are different, which are similar to the Hague, to the ICC. And that one has pre-trial chamber. It has a different procedure, totally different from our criminal justice system. Honorable Chair, now I think what Honorable Katuntu said is important, that we will need to come here, and I've tried to, we are working on pointing to the specific pages, but it's going to require that every member takes time on their own to look at the judgment. But we are going to we are preparing a guide. I had started on it last evening, but I wasn't able to finish. A guide on the pages and what was said by every court. And I can state, honorable colleagues and members, without any fear of contradiction, that the court did not, the Supreme Court did not at any one point say civilians cannot be tried in the general court martial. I want to state that as without fear of contradiction. The Supreme Court did not say that civilians cannot be tried in the court martial. Like Honorable Katuntu said, different judges went through it in different ways and arrived at a different conclusion, to the conclusion that the court martial as it were constituted, and the way it had been set up in the law was not constitutionally set up to try civilians. And on the issue of the offenses, they said they were vague. So, colleagues, it is important that we all really get an understanding and an agreement on what the Supreme Court said. And I have got some of the pages here. It's so far I'm at page 11. But each court was saying the court martial as it is set up, where you're not appointing persons properly, where they are not lawyers, where there is no independence, that court martial that you have there cannot try. But I'll just quote from some pages to exactly say what I understood the Supreme Court to say. The Honorable Chief Justice at page 126, 127 says, while there is no international treaty to which Uganda is a party, which contain an express provision providing trials of civilians by military courts, there is nonetheless international consensus that the jurisdiction of such courts needs to be restricted. That was at page 134 he says, it is clear that international jurisprudence, even if the move is general to restrict civilians in military, the tribunals, the practice oscillates between complete abolition of civilians in trial courts and trial of civilians only in certain cases of an exception. He went on to say the trial of civilians by special court should be done only in exceptional circumstances. That is at page 136. At page 141 he says, I take cognizance of the crucial need for military courts for the maintenance of discipline. I also note, and which thereby ensures the defense of and security in Uganda. I also take note of the fact that there may be need to extend jurisdiction of military courts to cover civilians who fall within the few exceptions in application of the law as it obtains to other jurisdictions. At page 148, in conclusion, for the blanket trial of civilians, in conclusion, the provisions for the blanket trial of civilians, in the military courts, either as principles in 117H or as accomplices, does not satisfy the limitation requirements The unconstitutionalized the act of trying civilians in civilian courts under those provisions unconstitutional. So we need to read these provisions. We need to read the judgment of the court in extenso, in full, to understand what the court was saying. I'll go now to Honorable Justice Honorable Justice Monica Mugenyi also concluded that I think I would therefore hold that the majority that the civilians that aid and abet civilians that are military persons in commission do offense in the service of, do by their actions subject themselves to military law under the act. At page 120, at page 22, she says, I do additionally find that the provisions do not constitute exceptional circumstances under which the trial of civilians in military courts should be justified. And to that extent, it's inconsistent with the provisions of the Constitution. Justice Mwanda agreed with the judgment of the Chief Justice. Justice Pase Mugenyi said, Justice Pase Tuhaise, Knight Tuhaise says, in its present state, the General Court Martial, though lawfully set up by an Act of Parliament, deriving such powers under Article 129(1)d, or is, in its present form, competent only to try matters relating to discipline of members. So she's also saying, in its present form, it can only try discipline, but cannot try things. So I'll share, Right Honorable Chair and members, we are going to write out and try and point out to you the exact provision, the exact paragraph where the judges said whatever they said on the issue of thing. I think for me, what I understood this to mean is that civilians can be tried in the General Court Martial in exceptional circumstances. The question for this committee and Parliament, what are those exceptional circumstances? What we have brought to you, colleagues, is what we think are exceptional circumstances. I beg to submit, I think.
Chair,
Chair.
this is for the Attorney General because justices of the Supreme Court, having made all those analyses, in the final orders, they did not put that. Why didn't they reduce that into an order of court? You will explain in there. All that I think, because when a judge is saying, I think, and I did this and this, in the analysis, but in the final orders, stop short of putting that in their final orders. Later, I also want you to confirm to this committee two things. If we process this act, and by Friday, it is passed, and by Monday it is signed, will it apply to the 400 plus people who are still being held in defiance of the very Supreme Court? Will they be tried under the new act? That's a question I want you to answer.
Well,
in case the act
first
comes
of all,
into force.
If the Parliament...
No, let me finish. Just one more. Then thirdly, why do you think their lordship said transfer all and did not say use others? Transfer all. Those three. If you can answer now, it's okay, but later it's still fine.
Chair, why we are trying to safeguard this power, it is because the army has been involved in petty cases. Bring the Attorney General to one where Captain Ola was added on a case of Dr. Besigye, yet he was remanded months and months before the case was committed. The army has lost trust, and given this power that it can easily come up with a case and it claims conspiracy, and an individual who is a civilian can be added onto another case. It has been realized that many cases, somebody is picked from nowhere and then added to one similar case. And this brings it to that point that they have broken the trust, that we cannot give them such power. As well, how far with transferring all these cases that we are sent to the civilian courts?
Honorable Chair, before he takes leave, statute of tenure and privileges, part of one, are they high court judges? Where is the privileges framework as the extension of security and independence?
Thank you very much. In government since 1986, by legal notice number 1 of 1986, the court martial has been here, and we were happy with what the court martial was doing until a few cases that we are having a problem. Because I hear some people are saying they are happy with the court martial, you say you're not happy with the court martial. I think together we can sit down and say, what is it that we do not like? What is it can we do to make it better? I don't think it is wise to throw out the bathwater as the child